Hello and welcome to our final lecture on due process and incorporation. And this lecture is about modern tests and doctrines. Now, we've spent a lot of time talking about how the court attempted to define due process in the 19th and early 20th centuries. We've talked a lot about how important the concept of a right being fundamental was to the court, so much so that at one point the court says that only fundamental rights are part of the meaning of due process contained in the 14th Amendment. And I want to remind you about what we discussed earlier concerning the role of personal and individual autonomy, especially when we were talking about the Hurtado test. Now remember, the Hurtado test as a 19th century test is a three-part test for determining whether some right is part of the meaning of due process in the 14th and should be protected. And of those three prongs, two of them focused on the power of the state to create order through democratic processes. So it's just basically is majoritarianism. And only one of those three prongs referred to the rights of individuals to exercise liberty. Well, in the modern era, things get flip-flopped. The right of the individual to exercise the liberty interest becomes more important, or at least as important, as the power of the state to create order. This is a dramatic change, and it has to do with something called burden shifting. It's extremely important. We're going to talk about a little bit when we get to the old, comparing the old and the new ways of applying due process to the exercise of rights. Okay, so remember our overview. We went through the before ratification. We talked about Barron and Scott, initial interpretation in Slaughterhouse, 19th century due process. We talked about Hurtado, Palco, and twinning in that lecture. And then early 20th century, we talked about Shelley and Duncan and how the court in Shelley found that property interests were more fundamental than the power of the state to create order. So the individual exercise of property right was more important. And then in Duncan, we see a case that looks much more like Hurtado and Palco in terms of its subject matter, criminal process. But there the court decides that the right to a jury trial is fundamental because the power of the it limits the power of the state over the individual in the criminal rights process. So now we get to this modern due process section. We'll be talking about two cases, Korematsu and San Antonio v. Rodriguez. Now, Korematsu is actually Korematsu versus the United States. It's not even a 14th Amendment due process case at all. The way you can tell, actually, is whether a state is named as one of the members. That doesn't happen all the time, but you know, Palco versus Connecticut, Hurtado versus California, Twinning versus New Jersey. These are all cases involving the 14th Amendment because the 14th Amendment applies to states. Well, here we have a case that establishes, it's the most important case in establishing the modern interpretation of due process, and it didn't involve a state at all, and thus didn't involve the 14th Amendment. It involved the United States. If you've read this case, you'll know that it is a case that occurs after the unprovoked attack upon the United States at Pearl Harbor by the Japanese Empire. And the United States was really open to attack along its western seaboard. There was great fear that there were a Japanese spy network was operating on the west coast. This was in fact the case. If you've seen the movie Unbroken, or read the book, as I have, didn't see the movie yet, but if you've read the book, you'll know that when the main character is taken into custody by the Japanese, he's interrogated by a person, a Japanese citizen, that he went to school with at UCLA. So there was a Japanese spy network along the West Coast, and the United States moves to exclude all persons of Japanese ancestry, whether citizens of the United States, born in the United States, naturalized here, or whether citizens of the Japanese Empire living in the United States. The United States moves to restrict all of them from the western seaboard, and does so by having them report to detention centers where they will then be processed and shipped out to what amounts to concentration camps, but detention centers. Um, you may want to do some looking here. There was a really interesting interview that George Takei gave on The Daily Show when Jon Stewart was the host. And he talked about his time being interned as a young boy, 4 and 5 years old, here in Arkansas, where I live and work. The Arkansas State University has turned that place, Rowan, the Rowan concentration camp, has turned it into a museum. And George Takei came and talked about his experiences there as a prisoner, basically a prisoner there in Arkansas. So this case, Korematsu, doesn't really deal with the 14th Amendment at all. It deals with a policy of the United States that restricts a people, a class of people from the the western seaboard, and deprives them, not only classifies them, but classifies them for the purpose of depriving them of the fundamental right of their liberty. Liberty of movement, liberty to, I mean, all of it's taken away, property, everything. So it does involve a racial classification, and the court later applies the logic that it uses in Korematsu to the states when they classify based on race. Now, in this case, Korematsu, it involves war, but the test that the court creates, suspect classification, is a test that the court then uses to evaluate state laws that create racial classifications later, in particular during the civil rights movement, but still today. So what is suspect classification then? Well, a lot of people and even Supreme Court justices talk about it as suspect class, as if the class itself, Japanese or African American or white or whatever, is suspect. But that's not what it is. It's not suspect class, it's suspect classification. It's the classification made by government which is suspect. We suspect it, actually, of being unconstitutional. That's an important distinction, I think. Semantical, but it's important. African Americans are not a suspect class. The classification of African Americans may be suspect. Japanese are not a suspect class. You know, we suspect them of being disloyal or something. No, 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 no. It's the classification of them that we think is suspect. And the court says in Korematsu that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. So they're talking about this in terms of the policy being suspect and not the class of people. So what's the test? There's two parts to it and then a third component that's important. First of all, the court presumes that racial classifications are unconstitutional. In other words, that's what it means when it says they are subject to the most rigid scrutiny. This is a dramatic change because in the past, all of these cases we've talked about up until this point, Hurtado, Palco, Twinning, Chicago Burlington, all of those cases, the policy of the government was presumed constitutional even after the Supreme Court had determined that the right was fundamental. Here, the court goes, we're not going to do that anymore. We're going to presume unconstitutionality where a policy impacts a fundamental right. And, you know, people have a fundamental right not to be classified inappropriately according to their race for the purpose of depriving them of a fundamental right like education or property ownership like in Shelley, or their liberty of movement like in Korematsu. So that's the first part. The second part is that when we presume unconstitutionality, the burden is shifted to the federal government. or the government, in this case the federal government, the burden is shifted, and it is not the burden of the individual to show that the policy is unconstitutional. The burden is now on government to show that the policy is constitutional, and the only way they can do that is to show that the policy is justified by matters of pressing public importance. That's another way of saying compelling interest. Government must have a compelling interest, and only that compelling interest will justify the policy. In Korematsu, the compelling interest was war. That's one of them. In affirmative action cases involving higher education, the compelling interest, according to the court, is diversity. So having a diverse student body is actually a compelling interest, just like war is. I actually buy that, frankly, being a university professor, but that's a discussion for another time. And also, the third part is that a racial justification alone will not satisfy the court. Okay, what does that mean? A racial classification alone will not satisfy the court. Let's think back to Loving. The policy's sole purpose was racial in Loving. They didn't have any other purpose in mind. They weren't trying to stop war, to protect the public, health, safety, or welfare, by stopping the plague. There wasn't any of that. The whole purpose was to maintain racial purity. And in Loving, the court says a racial justification alone does not satisfy the compelling interest part of the test. So the court notes in Korematsu, actually, that the purpose of the Japanese exclusion was national security. It was war, grave, imminent military danger. And that was enough to satisfy the court. In fact, they completely discounted the racial component. Justice Hugo Black discounts the racial component to this policy, and he says it's not racial animus that's leading to the exclusion. In fact, the Japanese American citizens are just bearing burdens just like any other citizen would. When we know for a fact that the general in charge of the western coast of the United States made statements to the press like, the only good Jap is a dead Jap, or there's no way that any Jap could be loyal to the United States. And he used a bunch of other racial epithets that I don't want to repeat. And the court completely ignored that and said that no, it was war that justifies the decision. Okay, well, so that's the origin of the test. Let's look at how the court applies it in a case called San Antonio versus Rodriguez. Now, this is a case involving a modern application of the suspect classification doctrine. This is a complicated case because it's not just a due process case. It's also an equal protection case. It's a combined claim. So there's a claim by Rodriguez that he has a due process right, a fundamental right to education. And that's silly, right? That's not in the Constitution. There's only one problem, though. The court had said it, that education is a right, had said it in a case called Brown versus Board of Education. So he says, and he references Brown, he says, education is a right. It's fundamental and I have a due process right to it. And the equal protection problem is that the state of Texas has classified me inappropriately according to my economic class, because he was a poorer person, and their doing so has deprived me of the fundamental right of education because my children are getting a poorer education. There's being less money being spent on my children than there are on children who go to school district in richer neighborhoods. So how does the court treat this? I mean, it's said in Brown that education is a fundamental right, but it's never acknowledged economic class as an inappropriate classification like race would be, a classification that would be presumed unconstitutional and could only be justified by the gravest of circumstances. So how does it treat it? Well, the court doesn't buy either one in this case. It says there is no due process right to education. Education is not a right. The court says this in San Antonio v. Rodriguez, and that overturns Brown versus Board of Education. I'll bet you didn't know that, but the statement in Brown that education is a right is no longer good law. And secondly, the court says we don't buy the idea that economic class should be considered a suspect classification for which we suspect that any policy of government is unconstitutional. It goes through a long expose on this and says, it's not an immutable characteristic. People move across classes. Nothing prevents poor people from buying less expensive houses in rich neighborhoods, or rich people from buying houses in poor neighborhoods. You just can't tell. You can't separate people out so carefully. So we're not going to buy that either. And in the old days, this would be the end of the inquiry, right? There's no fundamental right. There's no equal protection violation. Texas can do whatever it wants to. But this was not the old days. This was the new days. And the Supreme Court then subjects the Texas policy for funding education to a rational basis review. Of course, it passes that review and Texas wins the case. But let's talk a little bit more about this. Because this case, San Antonio v. Rodriguez, really points up what's the difference between the old way and the new way of evaluating due process claims. So under the old way, it worked like this. And by old way, I'm talking about Hurtado, twinning, everything all the way back to slaughterhouse cases. First thing the court would ask is a right fundamental? If the answer was no, then they would say, state can do what it wants. If the answer is yes, then we have to go on to this next point, which is we're going to presume that the policy is constitutional. The individual bears the burden to prove that government does not have a rational basis for restricting the exercise of the right. So the individual would bear the burden, even though the court had determined that the right was fundamental. What is this rational basis review? Well, it's just a reasonableness, really. Is there a connection between some legitimate goal that government has and the policy? Any reasonable justification will do, even one that the court finds but that the state itself didn't find. And that's all rational basis really is. What's the new way then? Well, we start out with the same question. Is the right fundamental? If yes, no, you'll notice, actually, I want to point this out. Look at the old way. Is the right fundamental? And we go to, if no, we uphold. If yes, we presume constitutionality. Now look at the new way. Is the right fundamental? If yes, we presume unconstitutionality. It's exactly the backwards. Government, not the individual, bears the burden to show that the policy is justified by a compelling interest and is implemented narrowly. Okay, so this is burden shifting. We've shifted the burden from the individual under the old way to the government under the new way, if the right is fundamental. Now, what happens though if the right is not fundamental? Then we go to the next point. If the right is not fundamental, then all government has to do is pass the old test, which is the rational basis test, which, as I said, simply requires that government show a reasonable connection, a rational connection between some goal that it has that's legitimate and the policy that it's implemented. And actually the burden rests on the individual under rational basis to show that there is no rationality to the policy. So I'll give you an example here. Do you have a fundamental right to drive a car? No, you don't. Okay, so we drop down to the second point. It's not a fundamental right. Now we know that the individual bears the burden. Now let's say that the policy that we've got is one in which the state of Arkansas has said redheads may not drive cars. We will no longer issue licenses to drive cars to redheads. Why? Redheads are inherently hot-headed, and thus they cause more accidents. Well, the burden would be on the redhead bringing the lawsuit in this case, but I think he or she would win their case because there is no statistic and no reasonable explanation under any circumstances that would justify creating a classification called redheads and then depriving them of licenses, even though there is no fundamental right to drive a car and to hold a driver's license. So this is the new way, and it involves burden shifting. I would encourage you to look very carefully at this distinction. What's the difference between the old way and the new way? It's really, really important. Okay, thank you so much for listening, and that is the last lecture in our due process and incorporation case study.